It's a beautiful Saturday morning, and as usual, we're always happy to know you're there with us on the program Politics Today on independent television and radio. Well, you may say, I don't like politics. Whether you like it or not, in a sense, it will determine how you live, how you talk, how you succeed. I mean, virtually everything about your life will be determined by politics. And that's why we're saying in the 2023 election, everyone needs to be involved actively. And the only way you can do that is to ensure you've got your PVC. So on the show today, I'm asking the question, you listening right now or watching right now, do you have your PVC? If you don't have your PVC, you're definitely not wishing this country well. It means that whatever happens, at the end of the day, you take full responsibility. Interestingly, if you go to INEC office, you'll be amazed the caliber and the quality of persons out there who are highly placed, who just sit on the fence. They join in the social media bandwagon, they join in all the talks and rhetorics. That won't take us anywhere. The only way we can move forward as a people is if we take our destiny in our hands. And that's what the youths are doing. Just yesterday, we heard of a mega entertainment group that was put together by youths in Edo State, but specifically, it was for a purpose. The purpose is to ensure that more and more people are able to register and get their PVC for the 2023 election. With that, I say welcome to Politics Today. My name is Sonny Duke Okosun. Our major talking points on the show, we're looking at some of the latest rulings by the Supreme Court, first on the Hijab, and then secondly on the Electoral Act, of course, that has perpetually banned elected officials. We'll talk about that. And then the issue of placeholdership in our political space. What does the Electoral Act say, and what does the Constitution say? All of these we'll be looking at in the next 15 minutes on the program. But let me quickly welcome our panelists. I'd like to thank very especially Barrister Daudu, Sonny Daudu, who is a public affairs commentator. He's also a member of the Benin branch of the NBA. Barrister Daudu, thank you for joining us on the program.
Thank you very much.
Also have with us in the studio, Godsent Erosa is a public affairs commentator, a businessman, and is also a huge personality when it comes to youth engagement and mobilization. Usagi, thank you for joining us on the program.
Thank you so much, Sonny Duke. Good morning, viewers. It's my pleasure.
Okay, we'll be expecting Barrister Press Aikboka, who is the Executive Director of Freedom of Information Council, to join us any moment from now. But let's get the show started. As usual, our studio line will be open so you can call and be part of the discussion. You can also follow me on my personal Twitter handle at Duke Okosun. I'll follow you back. You can follow the show as well, posting a comment on our Twitter handle here at ITV Radio NG. Okay, let's begin with the Supreme Court judgment on the Electoral Act 38, Clause 12, which was a major issue. That act that bill was sent to the National Assembly. It was passed, and then it was sent to Mr. President, who signed it. And then later on, Mr. President, on the advice of the Attorney General or in cohort with the Attorney General, turned back and requested for the Supreme Court to set it aside. What does this mean for our democracy? Let me begin with you, Barrister Daudu.
Well, thank you very much. First, the process of lawmaking and the process of amending the Constitution is stipulated in the Constitution itself, Section 9 thereof. And once the process has been completed, the President becomes first choice official in respect to that Constitution, the constitutional amendment. In this wise, the Electoral Act. Now, it was actually a somersault on the part of the executive to request that a bill that has passed through the processes. We have 5 stages in amending an act. And the act passed through those 5 stages, and the president have assented. immediately the president assents to that bill, it becomes an act of the National Assembly, and at that stage, the president becomes fortress official. It means that the president cannot do anything, cannot request the National Assembly to either delete or remove, or by themselves directed to remove any part of that electoral act. So the Supreme Court was right to have said that the request that Section 84, Sub 12 should be deleted or removed was done in error. And as such, the president cannot request. The court even went further to say that it was an abuse of court process to request or even file a matter in respect to that act, because it has been completed, you have signed. Because the president had an option not to have signed. If he feels that the section, yes, was not comfortable with that section, he could still return it back and specifically now state the reason on this point that Section 84 should either be modified, deleted, or amended before he can sign. But this is why he didn't do it. He signed. He started making.
So you're saying by virtue of this outcome, Mr. President was misadvised?
Was misadvised because even the Attorney General is part of the process of amendment. Once an act or a bill is set from the National Assembly, there are processes that he passed through before getting to the president. The president is actually the last person he gets to. It has passed through some scrutiny. He also goes to the Attorney General's office. The president has a special advisor on legislative matters, one. Yeah. He goes to that. He goes to the special advisor to the president on legal matters. The special advisor on legal matters looks at it. Then, after looking at it, he makes his observation. He sends it to the Attorney General. The Attorney General will now fine-tune it before sending it to the president. There are processes that he follows even the presidency. It doesn't just go to the president for assent. Okay. So, all of these processes were completed.
Okay, let me proceed there. What this means is that political appointees remain banned from participating in party primaries. Is this not an infringement on their own fundamental human right? Then on the other side, can we say that even the legislators shot themselves in the foot on account of this amendment to the Electoral Act?
Let me quickly first of all applaud the judgment. You know, I remember some time ago we had a discourse along this line, and for me, my position was very strict on the matter. We must always learn to understand that our democracy is building, and it is the actions and inactions of these so-called politicians that strengthen or undermine the integrity of the viability or the credibility of our democratic processes. For me, it took a lot of bravery and, you know, trying to be on the right side of history in accordance with what the law says for the supreme, about the 6 or 7 man judges that sit on that issue, to have taken a very straightforward decision. It has never made sense to me as a member of this, a citizen of this country, for you to insist that appointees automatically becomes delegates while holding their positions. You know, I remember then we had a contention on the ground of morality. You know, even though we say the law is law, but there is also a part of the law that has to do with what appeals to the common sense. Okay? If I am an aspirant and I have God knows how many as possible political appointees, and because I want to come back to power, they have no choice. They become people that are coerced in doing my bidding. You know, so on the backdrop of that, on that moral analysis and stand, I want to thank the Supreme Judge for standing on that, because more so, you should also be aware that in a country like ours, it's not so much easy to take a decision or to come to a conclusion that seems, in quote and unquote, to be against the president or the Attorney General of the country, even though there have been quite a number of dissatisfaction among some. I think one judge and some lawyers complained that the Attorney General was trying to, you know, interfere or manipulate the court processes before it got to the Supreme Court. So I think that decision has come to strengthen our democracy. be that as it may, we must always know that the decision of the president and the Attorney General was what we call an afterthought, you know, because like the judgment clearly analyzed, you have already assented to the bill. The only way the president would have thought of, okay, possibly an amendment, introduce another proposal towards amending that. But for you to boycott what, we should also remember that the National Assembly has saddled with the responsibility of making these laws. You know, for you to have signed and consented to a bill, then 4 months after, you suddenly realize. Now, during that period, if you could take your mind back memory lane, there were a lot of suspicion because there were a lot of political or some political appointees that wanted to become the flag bearer of their, you know, respective states, states, and even at the national level, presidential flag bearer. Yeah. So now there was this public opinion that it was an attempt to hijack the system in order to favor them. You know, so for the Supreme Court to have come and call a spade, I think that's a plus to the judiciary, and it also goes to strengthen our democracy and increase our faith and confidence in the judicial processes. Okay. You know, because from my own point of view, I may not be a lawyer, it has never made sense for the president and the Attorney General to try, should I use the word circumvent, or try to use the Supreme Court to reinterpret the law, or for the purpose of some few individuals' personal gain or selfish interest. You know, so it's a plus to democracy.
Okay, Barrister, I'd like you to give us a head start on the fact that political appointees remain banned by this development with Section 84, Subsection 12 of the Electoral Act, following the judgment that came out, on Thursday. Yeah.
Yes, you see, as the law is now, they remain bound. But it's a ground of challenge. See, it's what you give to the court. It's the ground of challenge. There's a ground of challenge if you want to challenge that act. But we are saying that it shouldn't be the president nor the Attorney General. There's a ground of challenge. The ground of challenge will be, for instance, those who are named, persons who are appointed, who feel, for instance, their rights. If I want to borrow your question first, that whether or not their rights were not affected, they would have go by way of challenging the law for particularly naming them, and not the president requesting that it should be deleted. In such instances, you can challenge the law on grounds of making it an ad hominem legislation. An ad hominem legislation is a legislation which is targeted at a group of persons. On that ground, the Supreme Court can interpret whether or not it is not an infringement on their rights. But in this wise, it was not them that were challenged. It is not those who were appointed that went to court. And the ground of which they went to court wouldn't be a ground of saying delete the session. It will say that that session is ad hominem. It's a law specifically naming a group of people, excluding them from participating in the election. And as such, the court should struck it down for affecting their right. But that was not the issue here. The issue here was that the president went to court through the Attorney General and said that the session should be deleted. You cannot dictate for the National Assembly how laws should be made, because, as he said, if you look at the tenor of Section 4, the legislature have been empowered by law to make laws for the good governance of the country. And as such, the president cannot interfere. But there's a ground of challenge. You can challenge that law on itself. But those who will challenge are those who have the local standing to challenge whether or not that law is an ad hominem legislation or otherwise. Now, if we go further in respect to the provisions of that Electoral Act, you will see a situation where the National Assembly also, they are also trying to interpret that law. That is why you have a lot of challenges, which now says, for instance, it is only elected delegates that can participate in primary. That is not the tenor of the act. If you are elected, not appointed, you can be a statutory delegate and vote. But even the National Assembly are taking a somersault, even though, because they are not too sure of what the law is. That is why they too, they are not so comfortable with the act. But the act is clear. But the only challenge we have now, the act itself in totality has not been challenged in court. It is only the section that says that, Section 84, Sub 12, that says that political appointees should not participate. If they must participate, they must resign. that the president says should be deleted. Not even that it's being challenged. But he is saying that he is detecting. What the Supreme Court is saying that you cannot detect. If that session was challenged on grounds that he specifically single out a group of persons, and those group of persons file an action, then it will be a different result, if any. But as it is, those appointed cannot vote. If you are appointed in any political office, you can't vote. And those who voted in some primaries or who were used as delegates can also be a ground of challenge of candidates who emanated from that. Because some persons were still deliberating as to whether or not they can vote. And some parties closed their eyes to it. By this Supreme Court judgment, their primaries have been voided. And you will see, following from this, subject to the time frame for challenging primary elections, yes, which is 14 days.
That's on the long run.
On the long run.
On the long run, primaries have been voided.
Yes, can be voided on that ground.
On the ground of the outcome of the Supreme Court.
Of the Supreme Court, yes. So, what that simply says to me is that those persons who allowed political appointees to vote, their primaries have already been rendered negatory. It has been, and it can be challenged even post-election matters. During post-election matters, you can also add to it that those who elected those persons during primaries were not persons who the law recognized, because at that time, the law was still extant. So it's not an issue that is even in the Supreme Court. The law was still extant. The Supreme Court had not invalidated or validated it, but to allow them to participate. So those elections, those persons who participated in their primaries, we render those primaries a nullity in the long run. Okay. So as we speak, clearly, the law is clear. If you are a political appointee, you participated in the primary election, your participation is void, and that voidness also affects the result of that primary elections. And going forward, they cannot participate.
The National Assembly, in a sense, do you think this amendment was done in bad faith? Against the reactions that have trailed it, since it emerged, that this is what the National Assembly has done. Do you think it was done in bad faith? Clandestinely done just to
give some disadvantage to certain people, as it were.
And personally, you can't rule out some things when it comes to politics, as in the politics of Nigeria. But to be very straightforward, I think the National Assembly did the amendment as they thought it is in the Constitution. They did what they thought was right, But you can't rule out personal interest when it comes to politics. You discover that just before the primary, there were already an infighting. There were words and backlashes between, some political appointees, even the National House of Assembly. But for me, I don't think the National Assembly took that decision, accepted the amendment in bad faith. Because, like we said, we must be able to realize that democracy is about the people.
Yeah.
What it means is that while we make laws and while we interpret laws, the judiciary, the people also have a say to be able to question such decisions. And even though we are also aware that even if the apex court have taken a decision on this matter, there is also ground for review based on maybe future occurrence or circumstances. Okay. But for that particular decision, the National Assembly acted to the best of their knowledge, in accordance to the provision of the Constitution as they thought, But the point is, the President and the Attorney General didn't really approach it the right way, like our legal, counsel have said. You see, there was a ground for the President to have refused signing that law on the ground that I have a problem.
Then he would have been criticized for not doing that on the ground that he's trying to circumvent democratic process, legislative process, and all of that.
You see, that is the reason why it was suspicious. That is the reason why the populists, our opinion as observers, became near perfect when you say there were a lot of personal interest playing in. Because why didn't the President see that at first before he assented to the law or consented to signing the document in February? That is because you need to realize that as a sitting president, you have a lot of advisors talking into your ears. And more so when you have the Attorney General of the Federation having his own political ambition and thinking that one of the ways he could have a headway is to get political appointee to be statutory delegates. So what I mean is that action and inaction gave room to a lot of suspicion that on the part of the Attorney General, there was no sincerity of purpose. You cannot come and accuse the National Assembly that they acted illy or negatively, because what they did, and don't also forget at that time that there was a lot of pressure.
Yeah.
You know, the government was already being criticized, both locally and internationally, for not assenting to the electoral law.
Particularly the first time it wasn't signed.
Thank you. It wasn't signed, and there was deadlines. The deadlines was almost encroaching, and the president needed to do something because the elections are coming. The INEC deadline is coming. Even at the time, the INEC was appealing to the president to sign the law so that they can have a direction and so that it will not affect the 2023 election. So there were all kinds of events playing out in that circumstances.
Okay. If you just join us, it's Politics Today on independent television and radio. Our first pull-out from our conversation today on the Electoral Act, Section 84, subsection 12, which of course has been laid to rest by virtue of the Supreme Court judgment, which means political appointees remain banned from participating in party primaries, which was a major point of contestation since that Electoral Act came into the public space. Well, our legal personnel here has said that there are grounds to re-engage that particular legislation, but let's see how all of that will pan out in the days to come. We just step up a little bit on our conversation today on the program. This time we'll look at something quite, even though the Supreme Court hasn't made a pronouncement on it, but there are grounds to accept the fact that this is what is doable. Talking about placeholdership in Nigerian politics. If you don't understand what that means, it's such an interesting issue that is playing out. It's always been there, but it hasn't got into this peak in our political development. The Senate president contested for presidency, for the position of president, and while he was at that, someone was holding his senatorial seat for him. He was holding that place for him. So that person became a placeholder, all right? And then Senator Godswill Akpabio also has a similar fate, all right? Now, the presidential election is over. The Senate president wants to go back and take his seat and have INEC recognize him as a candidate of his party, the APC. The man, Honorable Martina, is saying that, look, I went for this election. I won it pop and plain. I am the candidate of the party. Well, Mr. Senate President said, no, you just had that position in trust for me. Now I'm back to take that position. You're telling me this. We heard before now that when the APC in Borno State submitted the names of candidates, it was the Senate President's name that was there. But as of yesterday, we heard that Honorable Machina has gone to the Independent Electoral Commission to collect the certificate indicating that he is the authentic candidate of the party. What is the legal background to all of this? Let me begin with you, Barrister.
Well, there is a place of holdership is synonymous with what party call substitution of candidates.
Okay.
But we will distinguish them. In the case of the Senate President and Godswill Akpabio, it's not a place of holdership.
Okay.
They did not participate in the primary elections for Senate. And as such, they have no place in Senate positions. So the party was wrong to even considering that Akpabio or Lawan were ever candidates for the senatorial position. The Machina was not actually holding forth for him. He could have only been holding forth for him if he has participated, won, then he now also contested for presidency. That was not the situation. Ahmed Lawan never participated in the senatorial primaries that were held. And as such, he was not holding forth for Lawan at the time the primary elections for Senate were considered. So it was wrong for the party. It was even wrong for the chairman of the party to have said that Machina was holding forth for Lawan. If holding forth for election, you didn't participate. Because the electoral act says that you must participate in all stages of an election before you can be considered as a candidate. He didn't participate. What was his score? What was his votes? At what point did he participate when he was participating for presidential primary, where he scored some votes? So he didn't participate. If the party makes a mistake of forwarding his name, Machina will retrieve the mandate from court. So it's in a good stead that they shouldn't even try that. But a place of ownership that is recognized is the kind of place of ownership, for instance, where some presidential candidates have not been able to narrow down who becomes their running mate. Now, they take anybody now, for instance, I'm aware that Tinubu has submitted a name. And that name is rumored to be a place of ownership. That is acceptable. But the acceptance of that can only be to the extent of the time for substitution of candidates, in which case he can be substituted. Not for Senate, where you didn't participate.
Okay.
Also, we also learned, for instance, in another political party, Obi, Labour Party, has also submitted the name of his DG as vice presidential candidate. That is a place of ownership. That can be substituted when they have resolved. But it also be to the extent to which the time of substitution permits. If within the time the law allows for substitution, they are not substituted, they are no longer regarded as people holding forth who can be substituted at any time. No. The law gives room for substitution of candidates for whatever reasons. In such instances, these persons who are vice presidential candidates can fit into the word place of ownership. But not the scenario tried to be painted in respect to Lawan and Akpabio. So, place of ownership, yes, is recognized. But it's recognized to the extent to which that the candidate whose place is being held for the now also participated in the election and won.
Who determines, let me come to you, who determines the candidate of a political party? Who determines who to be substituted, even if we are going to carry out such an exercise in ensuring that the political party presents a candidate? Who? Isn't it the political party?
Not entirely, because there are rules that guide the performance and operations of these political parties. No chairman can just come up, even in the case of substitution, against the will and the acceptance of the candidate that participated. Remember, the emphasis here is participation. Who participated in this election? I have not seen in the electoral law as amended, and even in the constitution, where somebody can be participating in two primaries at the same time, both the presidential primary and the Senate primary, I mean in pari passu, squarely. So, first of all, that theory should be highly discouraged, especially as it has to do with this key office, because even the place of substitution or place ownership that has to do with deputy, like the lawyer was trying to analyze, that has to do with deputy, not the arrowhead or the key person. You know, so that what the Senate president is contesting, for me, it doesn't tell well about his personality. And again, for our democracy, it is not healthy. There are things that, for me, shouldn't be subject to discourse. But where it gets into the hand of the law and lawyers like our respected Naudaye, these things should be put under check. Because imagine a Nigeria where you give a full legal backup to place ownership without the bottlenecks that are involved, especially emphasizing the participation of the candidate in question, or where you give the right of who determines the place ownership by the party chairman. That democracy is there.
Okay, let's take a short break.
Okay.
We'll be back with you with the rest of the program in a moment. It's still Politics Today on independent television and radio. Please stay with us. Thanks again for rejoining us on the program Politics Today on independent television and radio. Barrister Prest Egbaha, who is the Executive Director of Freedom of Information Council, is joining us now. Vice President, thank you for coming on the program.
Thank you.
Quickly, let's get your perspectives on the issue at hand, which has to do with place holdership. Senate President, Senator Ahmed Lawan, is the first person to more or less be affected by this. But I have a strong feeling that this practice has always been synonymous with our political process, where at the end of the day, it is a party that has a prerogative to submit the list of candidates that they want to submit. And many a times, you find some of those who are probably affected were feeling that this is an intra-party affair. Out of loyalty, commitment to the party, they just accept it in good faith and say, well, since the party has decided, let's let sleeping dogs lie. Why didn't this happen in this case?
I think every aspirant have the right to buy forms. You have the right to indicate interest for any office you are holding. And when you apply to get an office, you have filled the form. For APC specifically, they have a form they will give to you to also fill withdrawal. And there's some particular House of Assembly candidates, aspirants have said that nobody will accept those forms from you except that one of withdrawal.
It's filled.
Attached, yes.
I saw that form.
It's attached. So,
I saw that part of the form.
It places all aspirants on holdership.
Yes,
Are you getting it now? But that is not sufficient.
Why is it not sufficient?
It's not sufficient because by Section 31, to withdraw your candidacy means that you have to write officially and also be on oath.
So can we not say this form that they attached on withdrawal is an illegal form?
It's an illegal form, just a piece of paper. Either you are withdraw or you didn't withdraw. It's not what INEC will, it's not what the Constitution, the Electoral Act specifically, Section 31 requires. It requires a letter. It requires you to be on oath. It requires you to send those letters or affidavit to your party, the sponsoring party. The sponsoring party will now forward it to the Electoral Commission. Are we getting that? Those are the procedures. When I say place holdership is not known by law, I don't know what they're talking about. Those things are there. And as a running mate, if a candidate picks you as running mate, he submits your name, and if you want to bring another person, you as the person who will be taken has to officially also write withdraw. Section 33 recognizes it. A candidate can even withdraw. A presidential candidate can say, I'm no longer contesting because of ill-health, because of advice, or because of low funds, or because of strong opponents. You can withdraw. And say, okay, so another person will go. The only thing an INEC did in the Electoral Act is that there is a limitation, 90 days before the election. 90 days. So you have 90 days to do all that. So it is allowed by our law, it is regulated by our law, and it is something a bit ideal with our political process. Because people can start aspiration, and later on they have miscarriage of aspiration. So the law provides for you to withdraw by yourself, but there's a procedure. It must be on oath.
Fantastic. So just before we came, we talked about the Electoral Act 84, subsection 12, that the Supreme Court has given a final ruling, making it, which means that political appointees are banned, right? What does this portend for our democracy, in your opinion? Just quickly.
And what it portends for our democracy is that those who are already in offices should concentrate. You're already there. And if you have an aspiration higher, you should bow out within the time frame of the law. And if you don't bow, you're considered a nuisance. It's not, nobody limits your right to aspire. But the Electoral Act is saying that you have a time frame within which you have to leave. But the fact that the Supreme Court has struck out the case doesn't mean that the case cannot be commenced afresh, because it was a striking out. The reason is because the parties, the applicants at the High Court in Abakaliki were the President and the Malami, the Attorney General Federation. These were improper parties.
To the case?
Yes. If you are challenging the fact that political appointees cannot be appointed, cannot aspire, it should have been the appointees themselves, including Malami and other appointees. They say, okay, we are being impaired. Not the President who has already signed. He's not challenging the law which he has signed. And that is strange. Assuming but not considering that he has the right to do all that, what he ought to do is to file the case at the State High Court, perhaps the FCT High Court, to challenge the constitutional provisions. Assuming he wants to even do it in a way that he wants to claim that he has to interpret the law, constitution against the National Assembly, it is the Supreme Court that is a court of first instance for the case between the President and the executive and the nationals and the legislators. The case ought to have been commenced. So the case was commenced in the wrong court. It doesn't mean that because they have said that, oh, the case is struck out, the parties, the case was commenced wrongly, the High Court did the case, you have jurisdiction, doesn't mean that the section itself is sacrosanct. We are aware that there's already an appeal from Kano State Federal High Court to a Court of Appeal in Kano, challenging that same section by political appointees who said they have the right. So we are likely going to see that case again at the Supreme Court, when the Supreme Court now give a final decision on it. But of course, it's that case, I can submit that it is commencing at the wrong court, challenging that law to also be at the state high courts. Are you getting it now? So the construction of section 8412 of the Constitution, as far as the electorate as of today, is that political appointees who are still in office some days to the election cannot be candidate or aspirants for any political office.
Okay, we're just on the verge of opening studio line, so you can call and be part of the discussion. But let's just take you through the last lap of our conversations today on the program Politics Today, which has to do with another judgment by the Supreme Court, this time against the Lagos State government's restriction of wearing of hijab by female students to the school. The Supreme Court relied on Section 38 of the 1999 Constitution, which guarantees every Nigerian citizen the freedom of thought, conscience, and religion, and went ahead to rule that female students can't wear hijab to classes, and that has opened a vista of other issues. Just on Friday, a certain human rights lawyer, you're going to see that picture on the screen now, dressed as a traditional native doctor, wearing his traditional attire to the court to present himself as a counsel on the matter. We're told that immediately the judges in the court saw him, they had to leave the court for some few minutes before they reconvened, and he said he was exercising his fundamental human rights. There's a huge implication by virtue of this judgment. Some of them will be analyzing as we get to them. But let me start again with Barrister Sonny Daudu. The Supreme Court have given this judgment, and it's been triggering a lot of them. One of them is that perhaps next time you come to this show, you're probably going to wear some stuff, and then it's an expression of fundamental human right. What are your thoughts on this judgment?
Well, the Supreme Court judgment in respect to wearing of hijab was reached par equal.
What do you mean by that?
It was reached in error. The reason is that Nigeria is a secular state, wherein, of course, we have divergent religious, divergent thoughts, and divergent beliefs. Now, place of institutions of learning have a code of dressing, which regulates the dressing or the uniform that persons must put up. Now, wearing of hijab to schools is a violation of the regulations of such institutions. The reason is clear. For instance, in Nigeria, we have those who are white garment churches, who wear white garment. We have the Celestial Church, we have the Cherubim and Seraphim Church, who have their own dressing pattern. So if you say that every religion can wear anything they like, all these people will wear their white garments to primary and secondary schools. So you can't challenge them. It therefore means that the school have no dress code again. They have no uniform. So schools have their uniform. The thing is that if you are not comfortable with the uniform from a school, you will remove your child from there. The court has no jurisdiction, the Supreme Court, with due respect, has no jurisdiction to entertain that matter in respect to the uniform that a school has designed. Because when you enroll your child and worse into school, they give you a list. Books, uniforms, and so many other requirements. So if you do not meet one of the requirements in terms of dress code, then of course the school also should deny you admission. The school should not even in the first instance even allow you to, of course, be enrolled. Or shortly after, if you have been enrolled, you now change, now started wearing hijab, this child will be sent away. I think that is what happened in Lagos. But the Supreme Court reached that judgment on grounds of religion. It is not religion that is being preached in institutions. It's a place of learning. It's a place of having a cohesion, a harmonious living together in a uniform pattern. If, for instance, I put on my uniform, a man now go and cover his hair, body, and how do I know he's even a student of that? How does it associate? Because when you're talking about studentship, it's also good with association, fellowship. So the man, I wear my uniform, the other man wears hijab. I will not be comfortable. Again, as I said, the Supreme Court has no jurisdiction to entertain that matter in respect to wearing of hijab.
To what extent does this negate the secularity of Nigeria as enshrined in Section 10 of the Constitution by Mr. President Igbo?
Yes, the history of that case, there was a policy of Lagos State government in 2013 that no students, primary and secondary, should wear hijab to schools. And that policy was challenged by Muslim women, Muslim Student Association. They went to court, State High Court in Lagos. And the State High Court disagreed with them and dismissed the case, wherein they are claiming that stopping them from wearing hijab to school is discriminatory and offensive. Upon that, they went to Court of Appeal in 2015. And the Court of Appeal in 2016, their judgment allowed the appeal and said that it is an Islamic injunction to wear hijab. And again, it is their style of worship. The Lagos State government went to Supreme Court, asking the Supreme Court to determine whether what wearing hijab to school is discriminatory. And again, that hijab is supposed to be a dress for what? Place of worship. It's a religious right. So wearing your religious right dresses to academic institution is derogatory and offensive. And they asked the Supreme Court to rule on it. The Supreme Court, in a decision of 5-2, a full panel of 7, 5-2, agreed and allowed and dismissed the appeal, arguing that, holding that the decision of the Court of Appeal was right, that the dressing, forbidding them to dress that way they dress, is discriminatory, being that it's an Islamic injunction asking them to cover their face. So the aftermath of it, of course, is that it has the Supreme Court decision, of course, is saying that any injunctive directive in our religious books should take its bearing in both culture and in what educational learning. And that's the impact.
So that's why we saw this guy. I was saying just now. That's why we saw this guy like this in court.
Yeah.
So he's in order.
Well, the argument is right. The argument that
he went to the extreme.
Yeah, there is a way a lawyer should dress, and he dressed the way a lawyer should dress, and pardon himself with traditional, with religious attires, and. I don't know, but the discussion is going
okay, let me get your take on
and whether you can even be arraigned for the legal participation committee.
You see, for me, it was so baffled that a panel of learned men could sit down and come to such conclusion. I don't have to be a lawyer to put a lot of things on the table. I mean, even if for nothing else, knowing the level of, religious disharmony in our present society is enough for me to have thought that these 6 to 7 judges should have been able to have a different thought on the matter. They be that as it may. I think my co-discussants have made very salient points. If you say it is their right and religious right, what about the secularity of Nigeria? What about the view of other religious groups, like the traditionalists and even the Christian group? What about their view? Because let's also look at the fact that over the years, the government have taken over some schools that hitherto belong to the missionaries and even to the Islamic group. Till date, as we speak, it is even the Islamic group that is still holding on tenaciously to their traditions. The Christian groups are not so much involved as touching how do you dress or how do you come in. I think it's a decision taken in a hurry. It wasn't well thought. And for me as a Christian, it's not acceptable because it's not making sense. I'm using this medium to appeal to the team of judges and well-meaning Nigerians to pick up this issue. Because it's not making sense. If you say anybody could wear a certain cloth as it being fit to an academic institution whose solemn purpose is learning, not religious practices, then you can't stop the white garment man, like he has said. You can't stop a student from dressing like this. Even if the lawyers or the court says no, the court, they have a special dress, then you can't stop a man that is a traditionalist from dressing his child in red and red to go to school, because that is what you have allowed. You can't also stop these regalists. There's these people that carry dreadlock and whatever. Rastafarians. You can't stop them from coming to school in a Rasta. So where is the order and the sanity in the system?
Okay.
So it's sad and unacceptable.
0708365 4889 is our studio line. Dial it as okay. I've got you here, Barrister UL Osawage. Thank you for joining us on Politics Today. Please go ahead.
Good morning, Sonny Duke, and good morning, everyone in the studio. I just want to comment briefly on some of the issues that have been raised. Firstly, I want to say that the Supreme Court judgment on the issue of that section that talks about political appointees being bad, it was a striking out. It was not dealt with on the merit. So, and the reason why it was struck out is because of the parties. The Supreme Court made it clear. It was just a bench ruling that was delivered. When the appeal was adopted, the issue was picked up, and the Supreme Court struck out the suit on the basis that you cannot be the person who will bring this. So it can come up through any other person. It was not determined on the merit. We've not had the opportunity of this issue being determined on the merit. To recall that somewhere in the East, the Federal High Court has also made a decision that it should be struck, that particular provision should be struck down, and they went to the Court of Appeal. The Court of Appeal said, well, the parties who went to court, they also not the proper parties. However, if you had the opportunity of deciding it, this is the way we would have gone. So we've not had that issue determined on the merit. They're coming to the place of placeholdership. I don't think any of our laws really stipulates a position of placeholdership. What is there in our laws, as enunciated by my friend President Ibokan, is that you have a window where that section 31 and 33 of the Electoral Act says that where the candidate wishes to withdraw or by virtue of death. And when that is done for an elected position, election to that, the primaries to that position will be conducted within a particular time. So if you say the nomenclature of placeholdership is not used in our laws, and the intention of that law is not for placeholdership, the intention is for substantive. But by virtue of the fact that circumstances do occur that the person may die, or the person may not say, I don't want to anymore. But are you not telling me that those who are there now that you claim placeholdership and they decide not to withdraw, then you now rely on the law that no, it was a placeholdership? No. If they decide not to withdraw, they become substantive. And if they don't die enough, they become substantive. So there's nothing like placeholdership for the record. Then for the issue of on the issue of the hijab thing, I think like Mr. Daudu said there, it's our opinion. It cannot be given a judgment over and above that of the Supreme Court to say that it was done per incuriam. That is his opinion. I also hold that view because the issue was not whether the right to worship is being infringed. Nobody was putting them to their right to worship. It's also, but we'll talk about uniformity. That's why you have uniform. Are we saying that those in the military now, those in the police should not be coming with their traditional? Because that's the import of that judgment. I think they did not get, in my own opinion, that view of the premise upon which they based their judgment was faulty, because the issue was not challenging their right to worship, was that whether you can do that in a public place, because right to worship is private.
Okay, so Barrister, let me pause you there. Thank you very much for those useful legal counsel insights you brought to the conversation. We'll have a very limited time for more calls. Hello, caller. Good morning. What's your name? Tell us your name and where you calling from. Yes, go on. What's your name?
Hello, good morning.
Yes, good morning. Tell us your name and where you calling from.
My name is Ramat, calling from Ringgold.
Yes, go ahead, Ramat.
I quite agree with what Barrister Dowd said when he said if you are not convenient with the dress code of a particular school, you should take your child away from the school. Okay. That is if you are a Muslim.
Yes.
But I have a question for him. What happens to a school who admitted a student who is a Muslim and is on hijab, and after the admission, you start telling the child not to wear it to the school? That's hypocrisy. For me, if as a Muslim, you are not convenient with the dress code of a particular of a school and it's not in line with what you want for your child, you can take that child away from the school. Take it to another school who will accept it. Okay. But for school, my own opinion is for schools who are restricting people from wearing hijab, from their pupils from wearing hijab, you can put it in the constitution. They will know. When they come for admission, they know this school does not accept. If they want their child to be in the school, they be on it. If they don't want it, they will take the child away. Not after admitting the child, knowing fully well this child is a Muslim and this is the dress code, you start restricting. By doing so, you are infringing on the fundamental rights of that people to religion and association. Because you are very much aware this is who this person is. So if you are trying to imbibe what you are doing in that child, you are infringing on the
Okay, let me get Barrister.
Secondly,
yes.
When you go to public schools especially, it's not Islamic school, it's not a Christian school, it's not a pagan school, but they do morning devotion every day. And you never see a pagan or a Muslim who counters that. They all accept it. For me, in Nigeria today, we are just using religious sentiment to segregate ourselves. When you go to India, you will see Jews, you will see Muslims, you see pagans, you see Buddhists. When you go to their police station, those Indian women, they wear their saris if they want to. They are not restricted. Okay. If you want to wear your hijab, you can wear it. They are not restricted. Only is that you should wear it to an extent it will not cover up your uniform. That is what I expect many of all the schools to do. But for me, in my own opinion, I do not buy the idea of you taking your child to a Christian school and when they say they don't want this, you start yes.
Okay.
You start.
All right, Matt, let me pause it there because our time is up. I don't know if you have. You want to say something because you actually speak?
Yes. What I want to say, but not to be directly in reaction to what she said, because she has put it in perspective.
Yes.
Now, the lawyer that will dress to the Supreme Court cannot be challenged by the Legal Practitioner Disciplinary Committee, flow from the decision of the Supreme Court. Okay. The reason is that we have a dress code. Okay. It is the law profession that says you have a dress code. And we know that our Muslims, we have Muslims.
They have a dress code.
The dress code, but they wear the dress code of the court. If a school said I have a dress code and children violate the dress code and you validate it in Supreme Court, you can't challenge the lawyer who now wear agbada. The Yorubas have agbada, Ashoro. Okay. They will wear it to the Supreme Court.
That's how much time will permit us to have. But just to quickly add a comment to what Ramat said, it's also important that parents should make inquiries about what certain schools want and what they don't want, what they do and what they don't do. So you don't have to get your child or your ward given admission, and then at the point of admission you discover that certain things can happen on both sides. All right, so we need to put those information there in the public space. That's the much we have for you today on the program Politics Today on Independent Television and Radio. Big thanks to Barrister Preston Agboka.
Thank you for having me.
Barrister Sonny Dawudu, thank you for coming.
I'm grateful.
And Osaje Ruse, thank you for coming.
My pleasure.
Well, that's our program for today. We trust you had a great time with us on the show. But please remember, the responsibility to rescue Nigeria is ours, and the time starts now. Tell a friend, tell your father, tell your mother, tell your brother, tell your sister, tell your cousin, tell all your family members that they need to go get their PVC. It's not enough to register like we're doing currently. Most importantly is to take possession of that PVC and ensure you use it. The only way we can change the status quo of Nigeria, remove the hunger, remove the poverty, remove those who are not wishing this country well, those who have held this country by the jugular and they still want to perpetrate themselves in office, is to use our PVC to drag them out. And if you don't have a PVC, it means that you're also part of the problem of our dear country, Nigeria. That's my pull-out, my take-off point on the show. I want to say big thanks to you and wishing you a great weekend. Bye for now.